Good evening, everyone, and welcome to the Garage Series, part 1 of the year. That's why they sent me. For those that don't know, I'm Enzo Rondinelli. I had the privilege of being one of the first speakers at the Garage Series when it began over a year ago now in Vaughan. I can tell that it's gotten a lot better since then because it actually was in a garage. And I spoke on a pickup truck, and clearly the seating arrangement is much better today. So it is hosted by Paul Cooper, who's done a tremendous job making this event. So they heckle me and they clap for you. That's good. So there you go. Thanks, I have my mother here. So anyway, the event is getting bigger and better as time goes on, which is great to see. For those that were at any of the events last year, and you'll see obviously from tonight and moving forward, one of the main themes has always been mentorship, and that's the theme that runs through all the programs that Paul has put together and will continue. It's one of the things that he's worked on, and clearly he believes in it. And having both Greenspan brothers on a night when the Jays are in town also shows how dedicated they are to mentorship. So we're very happy that they can be here today. I'm also happy to see a number of crowns in the audience, because another thing that funny how no defense clapped, but that's okay. But again, that is also another thing we're hoping that these events help in terms of getting us out of the adversarial battleground of the courtroom and really get to more of these events where we actually see that, hey, crowns are people too.
One of the first things is note to staff, I'm not a 34 anymore. Okay, not a 36 anymore. Ask not what the profession can do for you. Ask what you can do for this thing we call our profession. The path to leadership is grounded in ethics. There's 4 steps: ethics, professionalism, mentoring, and leadership. Play the clip, please. Let me tell you a little bit of the history of our profession while we're waiting for this. I just quickly looked at the encyclopedia as I was bored, and it indicates that the history of our profession emerged when the legal system became too complex. Certain individuals with the required ability to master the law, like us, began to offer their skills for hire, and this created the thing that we do. Now, move forward a bit, and there were not rules, and there became abuse. And unfortunately, due to the dishonest, the unscrupulous, there had to be action taken, and that action came in the form of legislation, judicial interaction, and regulatory change. And the part of the regulatory change is to protect the thing that we do. The thing that we do, and it would sound a lot better after you heard Tony Soprano say that, but is, by its nature, it's loaded with its own set of internal contradictions. If you get the clip playing whenever you want to start, just go ahead. A lawyer is engaged in representation of a single private interest, your client. If you're working for the Crown's interest, the public's interest. But it's also engulfed with the concurrent and considerable overriding additional interest, and that's the public interest. The lawyer assumes the responsibility as an officer of the court, critically supporting and upholding the integrity of the legal system. So you have this conflict between your private and your public interests that drive you, and it occupies each and every decision you make every day as a lawyer. As you make your value judgments in the gray areas, where the choices are difficult and are challenging, you have to be guided. And we have developed what I say are 7 duties and obligations that help define our ethics. Number 1, duty to client. Duty to take on a case. Barrister's oath. I'm sure we all remember this. not to refuse to act simply because the prospective client is unpopular in an ugly red suit, or has a case that is notorious, or because of the serious conduct involved. And most paramount of all, you are to never refuse to act based on your own judgment or opinion regarding the guilt of an accused person. It's hard. You're human. Put on the blinders. Number 2, duty not to take on a case. If you are unable to provide competent representation, given either your limited experience, your heavy caseload, the seriousness of the case, a potential conflict, a conflict with witnesses who you previously may have represented, a conflict with witnesses who, if you were the Crown, could have been your client when you were previously at the defense bar, you do have an obligation to declare your conflict. And for defense lawyers, the obligation, once they are retained, is owned by the client. They must be informed, and you must always be prepared. You must know the law, you must know the process, and you must keep up to date with current changes in the law. You have to act honestly and deliver legal advice candidly and direct. You create an expectation level. And once that expectation level is created, you have to be direct and candid with your clients. You don't want them carted off after a long day in court and them yelling, "Flintstone, I'll get you, Flintstone." Maybe your client actually wanted an opportunity to reject your advice or reject your service. Criminal litigators could learn from each other. And they can learn also from civil litigators. It is amazing of the trial experience criminal lawyers have and the information about the process and how to run a trial and how to cross-examine an individual that they can assist civil lawyers with. But civil lawyers could certainly help teach us a lesson how to properly document a file and document the file properly throughout the process. We are poor with our paperwork. Number 3, duty of confidentiality. Enzo, did we get the tape working yet? Duty of confidentiality. Number 3, duty to keep all communications received from clients confidential. That was supposed to be confidential. Not the same as solicitor-client privilege, as you know, which is an evidentiary rule. This is something that is well beyond. It deals with all communication, and it continues indefinitely and remains even after the retainer ends. Number 4, duty to avoid conflict of interest. Avoid representing co-accused. Sometimes it's tempting to do that. Sometimes you don't readily see a potential conflict. They are marred with incredible conflicts, even unforeseen, they will come up and bite you. Don't place yourself at risk. For those that are young in practice, you have 2 people come into your office, they would like to retain you, co-accuse, send one to a colleague. Create a reciprocal relationship. Don't put yourself in a bad position. Another bad position as a lawyer you want to avoid is being a witness. And again, don't be in a position where you're cross-examining previous clients. Number 5, duty to withdraw or not to withdraw services. In these tough economic times, sometimes we're quick to jump on the record. We must understand that money does not form an aspect of the retainer. It is only one aspect, I should say. It is clearly not the principal component. Be careful. Please, 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 don't go on the record until you're properly retained, which includes the aspect of funds. There is no such thing as being limited on the record. Once retained, you have undertaken to a client, set up a level of expectations, and you cannot terminate that retainer except for good cause. And Mr. Green not showing up on the witness list is not a good clause. In today's climate, think of justice on target. Ask your friends in the audience that are from the Crown's office. It is becoming increasingly difficult for someone who goes on record with a limited purpose or with a limited retainer to then be removed from the record. Criminal Lawyers Association has created the CRAP team to help, but before you have to call them, don't put yourself in a bad position. There was wonderful leadership shown by the Criminal Lawyers Association and by Frank Addario in creating the boycott against legal aid and refusing to go on record for big case matters or murders or complex cases. And it was wonderful. I would have never imagined in all my years of practice that the Criminal Lawyers Association would actually become a recognized collective bargaining unit. But they did. Look at the power you have if you refuse to go on the record. Your client will learn that you are of value. Your client will learn that they must respect your value, and your client will learn that they're going to pay for your value. Be patient. This knowledge will come to the client, but it can only come to the client after you recognize this yourself. Deal breakers do exist, though, with the duty to act for a client. If you are over your head, and it's happened to me, and I go, mea culpa, please let me off the record, do it. You gain respect. If you find yourself, unfortunately, in a conflict, admit it. Get off the record. If client refuses good, sound advice, get off the record. If the client is attempting any type of deception or trying to turn you into a dupe, definitely get off the record. Again, getting off the record for convenience is difficult. There are other examples at times when the rule can be relaxed, but it's not guaranteed. Last week I was in court and I was amazed to see someone on a trial date attempting to get off the record and failed to follow the process that we are duty-bound by. The individual told the judge why he was getting off the record, disclosed confidential information, and wasn't allowed off the record. It's just amazing. Understand what the requirements are. Now, this is just a primer on ethics, so we're moving on to number 6. And before we move on to number 6, we're going back to the beginning.
Where were you?
I want to know what a zero growth in this family's receipts. There's the fucking money. You're supposed to be earners. That's why you got the top tier positions. So each one of you go out to your people on the street, crack some fucking heads, create some fucking earners out there. The guy. We talked about this over at the other place. With the guy. The councilman. What the fuck happened to that?
It petered out.
It petered out.
It died on the vine.
It died on the vine.
It died on the vine. The guy, he moved or something.
Oh, nobody knows what the fuck I'm talking about!
We hear you, Tom.
My uncle, the boss of his family, is on trial for his life. And what you people are kicking up to him is a fucking disgrace. You know how much lawyers cost? A major RICO like his? I'm the only one supporting him. This thing is a pyramid since time immemorial. Shit runs downhill, money goes up. It's that simple. I should not have to be coming here, hat in my hand, reminding you about your duty to that man. And I don't want to hear about the fucking economy either. I don't want to hear it. So, break it down for him. What two businesses have traditionally been recession-proof since time immemorial?
Certain aspects of show business and our thing.
Now that's it. That's all I gotta say. Frankly, I'm depressed and ashamed.